I thought it might be useful to talk about some of the elephants in the room. And for me, these are the questions and concerns that I have really over Bonita Peak. And I'm sure everyone has these. I remember a few weeks ago, I was with Wynn at Steamworks, and we were talking about our own personal elephants in the room. And there's some similarities and some different ones that he had that I really hadn't thought of. So I'm sure these aren't the only four. I know they're not the only four. I can identify another 4 or 5. But these are the ones that may keep me awake at night. Anyway, so I'm going to take a minute and introduce you to the 4 noisiest elephants that are in my room. And the first one, I really think that Anthony has really already talked about. And that is the implications of the Chevron decision, be it that the federal government is the largest landowner in San Juan County. And so I think that really Anthony did a great job of summarizing the decision. I think the one question that I have out of this, so what does this mean for the federal government? You know, we're all taxpayers too. And if the federal government, as Anthony's, both Interior, their remedial programs and agriculture's are somehow brought into EPA, how does that fit in with this too, considering that they will then become part of the PRP process too? And again, one thing to keep in mind with this decision is that they were really, the federal government, in this case, the Forest Service, and this dealt with the Cuesta mine in New Mexico, but it said, yes, you are a PRP, but it didn't really sort out what that meant in a sense, because it said, yes, you're an owner of the property. Now what your contribution is, it left that to the trial court. So again, we don't really know where we're going here. We don't know what the extent of this liability may end up being. So this is really another elephant that everybody's talked about here, and that is the significance of natural background in determining cleanup levels for the Bonita Peak site. And as Anthony indicated, I mean, this is an old volcano, and so it's a highly mineralized zone. And so natural background is truly a significant factor in the overall metals loading in the whole basin. And it makes sense that the extent is variable and really depends upon the stream segment. And then again, it fluctuates over time. And one of the points that Wynn made, hey, what happens with climate change? How does that impact this? How does that change what the contribution may be from natural sources in the future? I don't know that. Dean mentioned that, of course, Superfund states that the president shall not provide for removal or remedial action of a naturally occurring substance in an altered form or altered solely through natural occurring processes. And so there is a high percentage of metals in this basin that actually come from natural sources. The Clean Water Act, really what it says is it says that the mission of it is to restore and to maintain the chemical and physical biological integrity of the nation's waters. And in fact, there is another court decision that suggests that the phrase restore and maintain indicates that Congress sought to return water bodies to their natural conditions, not improve upon them. So for me, the question is, to what extent can we really work on remediation, and how can it proceed without really understanding this in detail? Yeah, I think that's enough to be said there. The third elephant in my room is, and it goes back to the listing itself, you know, the chocolate chip cookie approach, where we have this area and we've identified 48 chips that are listed in the Superfund site and the rest of the cookies there. But then, as Anthony suggested, this could be like Coeur d'Alene. We could have the extent of the site moving all the way down to Lake Powell, all the way down the San Juan and into the Colorado rivers. So, and Dean also mentioned that there's issues associated with if you're outside an NPL listed site, you certainly need to get a permit for basically a discharge to waters of the U.S. or waters of the state. So that's a concern. If you're within the NPL listing, you have to get approval of EPA to end up doing a voluntary action. We all know that over the last 25 years, there's been a lot of great voluntary actions and remediations that have occurred in this basin, led by the Animas River Stakeholders Group and Trout Unlimited and the Department of Natural Resources. So my concern here is, and of course we have to throw then again the whole Good Samaritan issue into this. But my question, is it possible, while we're talking about a Superfund listing, to also go ahead and support and integrate voluntary cleanups into the overall cleanup plan? And then the last one, and I understand there's a lot of good news here. The Bonita Peak Mining District is among Superfund sites targeted for intense and immediate action. This is really good news. So this is like considered right now to be one of the top 21 sites in the country. And that's great. But there's also over 1,300 sites on the list. And a lot of these are located in more populous states and a lot closer to population centers. And there may be more environmental and health risks. And as we know, the Superfund process takes decades. And again, there's the funding issue. And I think that Bob talked about that yesterday, that basically the real Superfund tax expired back in 1995 and wasn't renewed. And the funds are exhausted. So what happens is that all of the Superfund funding basically comes from annual appropriations, which has remained fairly constant over the last 4 years. And it's right about $1 billion a year. But you compare that to the cost of a cleanup at a very complex site, that could be $1 billion right there. So for me, the question is, right now, certainly Bonita Peak is a high priority. But will it remain so over the long term? Will people become disenchanted? Will the agencies become disenchanted? Will there be other releases and other concerns that basically will take away some of the attention that this site has received? And without really an ongoing funding mechanism, I do think that's a possibility. So I think that's probably all I wanted to talk about. I think this is now time to get some questions, and I invite the rest of the panelists, Jürgen, Dean, Paul, Anthony, and we'll try to answer whatever questions you have. Sure. Any questions? This could be the shortest panel on record. Sure, okay, great. Mm-hmm. Mm-hmm.
It depends on whether it was a mineral beneficiation waste or one of the 20 specifically identified mineral processing wastes. Because RCRA, unlike CERCLA, really kicks in on November 19th, 1980. Pre-1980, then RCRA corrective action doesn't really apply. And so just very quickly, the Bevel Amendment applies to mineral extraction waste, mineral beneficiation waste. Beneficiation is basically crushing, grinding, filtration, doesn't involve a lot of heat, acid, that kind of thing. That gets into mineral processing waste. They also identified 20 specific mineral processing wastes, which really reflected the political clout of the various industries who got these things identified. So what happens with historic waste, if it's beneficiation waste, it's always beneficiation waste, or extraction waste rock, okay? The only way to turn that into a hazardous waste is to mix it with a hazardous waste. If you have historic mineral processing waste that was deposited before 1980, it's not regulated by RCRA, but once you start messing with it, it's considered newly generated, and the bevel exclusion doesn't apply unless it's one of those 20 specifically identified mineral processing wastes. So unless you've had a mill with extreme hot acid leaching, for example, or a smelter, which, smelting, is something that really destroys the mineral fabric. I mean, I do a bevel talk then, and so I don't want to go there in too much detail. But basically, my view of mineral beneficiation is you're liberating the metallic ions from a mineral structure, whereas mineral processing, you're destroying the mineral structure. Okay, so that's really my distinction. So it really depends on what the process was or where the original waste rock tailings came from and what kind of process that was. Sorry for such an elaborate response, but that's an issue near and dear to my heart. Sure. Mm-hmm. Right. Yeah. Well, interesting. In the original CERCLA legislation before they revised it in '86, there is a defense for those who inherit property. So for folks who inherit property, what I would say is don't touch it, because you have the defense of inheritance. But once you get out and start making decisions regarding, the disposal of hazardous substances or compliance with environmental regulations, you may step back into CERCLA operator liability. For other folks, that's where the all appropriate inquiries comes in. Before you buy a property, unless it's absolutely pristine property, you should go through that ASTM process. And then you're allowed to get those defenses: innocent landowner, bona fide prospective purchaser, or contiguous property owner. But for folks who already bought it and are dealing with it, then we sort of go to the end of my slide presentation, because once you're in the mix in CERCLA, you want to, I think Betsy was speaking absolutely right when she said they want to do outreach to, the folks involved and work with EPA to try to get an AOC in place if you have to actually do anything to get contribution protection, covenant not to sue, and so on. But it's, once you're in the mix, Superfund is not super fun. I mean, it's, it's one of the most egregious statutes ever passed. I mean, this status liability, see, that's the thing about it. You don't have to do anything wrong to be liable. You just have to be a current owner or operator, or, the insidious thing about mine sites with a water discharge is you've always been having a release of hazardous substances. So anybody in the chain of title was an owner or operator at the time of release of hazardous substances. So even if you no longer own it, your ticket was punched back in the day when you did own it, and even if it's pre-CERCLA. So yeah, that's why I went to the end and said, what are our options? And they're fairly limited, but there are some out there. Yeah. Mm-hmm. Right. I mean, there are. It gets very arcane in CERCLA world in terms of there are two kinds of suits that can be brought. There's a contribution claim where you're seeking somebody's equitable share of cleanup costs. But there's also a cost recovery claim, right? Somebody can go after somebody else for joint and several liability for all of the costs. And the law in that area has been evolving. We've had a couple different Supreme Court decisions in the last 10 years that have basically said, everything you know is wrong. We're going to do it this way now. And so the courts are split about whether an ASAOC or consent decree protects against both contribution and cost recovery claims or just contribution claims, because the statute just refers to contribution. So that's an arcane area. It's a scary little piece out there, and it's not very certain. But getting contribution protection and a covenant not to sue from EPA is kind of the best you can do right now. And the other upside is you get the permit waiver, you get the bar from somebody challenging the remedial decision. So yeah, it's pretty limited options, but yeah, working with the agency is a good way to go.
Sure, go ahead.
Uh-huh. Mm-hmm. Right. If you have, many sites, many of which are abandoned, those are considered orphan shares. See, the thing about CERCLA is it's joint and several liability, but if the process plays out completely, you get to an equitable allocation at the end of the day. So, until that point, you don't use the words fair or equitable in CERCLA world until you actually get to the allocation at the end and says who's responsible for what. And a lot of it can be, who was on the site the longest, how much waste did they generate, volumetric temporal allocation, how nasty was the stuff they disposed, and so on. So for sites that are abandoned, those are orphan shares. If somebody has to spend money and incur response costs on an abandoned site, they can look to other viable parties for, who's left standing that's viable. In a very general way, at the end of the day, the orphan shares are generally allocated along the lines of the primary allocation between the parties. So if you have 5 parties, one of which is 50% responsible for the whole thing and the other 4 are responsible for the other 50%, the orphan shares typically are divided up sort of along the same lines, is how it works at the end of the day for the most part. So yeah, that's one of the problems is, that joint and several liability means you can be on the hook for the entire thing, even if you're only responsible for a small piece, if there's nobody else out there to go to. Yeah.
This was a really good series of presentations. There was one other statute I'm not sure you guys mentioned, the water infrastructure improvement convention, where year 2 that provides $20 million watershed funds when things brought online and parties together. We're really needing to put those issues aside. I don't know if any of you guys want to comment on that. It's very beneficial to the next area.
Not me.
The real question I had with regard to A-loans in the Superfund process, or relevant and appropriate requirements. In his video experience, I think it was in Mexico, that the state water standards and requirements and the permits are exempt, get worked into the Superfund process. So that the cleanup has to follow state water.
Yeah, the state standards do come into play in ARAR's world. These are sort of your cleanup standards. But, depending on, the technical feasibility, especially of high background concentrations, you may end up with, meet water quality standards to the extent practicable, right? Because again, under CERCLA, you're precluded from addressing naturally occurring contamination. And so it may not be viable to have an ARAR at a site with significant background concentration to have an ARAR to meet surface water quality standards, because the statute just doesn't authorize that. And so, we're kind of out on the edge of the envelope here. It's a really good question. But see, one thing about Bonita Peak that's so unique is the really high background concentrations. And, while we're talking about it, just you would ask for suggestions, Betsy, and a site like this, I would think that, one of the priorities would really be directing resources to figuring out what that background concentration is, what that contribution is, because that's really the starting point, you know, as directed by the statute is, you know, that's the floor at which you want to reach in terms of using the CERCLA process to get there. So I think that it's really important, you know, because that's going to affect the remedy decisions and the technologies and all that. And so, you know, unlike other sites, which are a bit simpler in terms of background contamination, this one, I think that a lot of resources should be dedicated towards figuring out where that baseline is, because then the CERCLA process really steps in above that.
Sure, go ahead.